Judicial independence is fundamental to the rule of law, ensuring that courts can operate free from external pressures, particularly from political entities. However, Nigeria's judiciary scored 0.4%, ranking 77th globally, which highlights significant concerns regarding judicial independence and effective functioning of the legal system. This also underscores a pressing need for reforms aimed at enhancing the integrity and functionality of the country's judicial system. So at this time, I'm being joined by Afam Osigwe, SAN, President, Nigerian Bar Association. Thank you so much, sir, for joining us on the show. Okay, so let's start this way. To what extent is the Nigerian judiciary independent, should I say truly independent from political influence?
Well, I would say that the Nigerian judiciary is largely independent, but when it comes to the issue of handling the finances of the judiciary, especially at the state level, is far from being independent, as the governors control the purse string of the legislature. That's why it's not uncommon in Nigeria to see a governor appearing on TV or issuing statement boasting about how they have built courtroom, how they have bought cars. You hear governors say something like, I bought cars for my judges, I take good care of my judges' welfare. I mean, they come off sounding boastful as if they're doing these judicial officers a favor, and sometimes it's not uncommon to hear that chief judges have to plead with the governors or spend long hours in the state government, in the government house, begging the governors to authorize that money budgeted for the judiciary in the state be released to them. And this, whichever way you look at it, undermines the independence of the judiciary. And sometimes also in some states, when the judiciary consistently hand down judgments that are not favorable to state governments, they are sometimes linked to refusal or non-release of budgeted allocations to the judiciary. While this may not in some sense amount to direct interference with the judicial independence, there are subtle interference with the judicial processes, because the affected governors will appear to be saying, because you give these judgments against the government or against the governor, your money will not be, the money budgeted for the judiciary will not be made available to you, which is a way of twisting their arms to ensure that judgments favorable to the governments are rendered by these courts, that these courts do not decide on the basis of facts and law, and also ensure that in giving their judgments, such judgments favor governments. Now, at the federal level, this is not very pronounced, and so the issue of ways of allocations to the judiciary is not as troublesome or problematic as you find in the states. But generally, the judiciary is independent, and there are a few instances where there may have been political interference by the executive branch in the sort of judicial function of the judiciary. But I would not agree with any ranking that gives the 0.4% as stated by you in the intro. But I would say that there is need to do more work and more advocacy to ensure that there is judicial independence. And it's a high degree of judicial independence as it relates to the financial autonomy of the judiciary.
Well, you actually say that you do not agree with the rankings, but then a lot of things you've actually mentioned that are not really as good as one would have expected happening within Nigeria's judicial system. But we're going to talk more about that. We need to go on a very short break right now. We'll continue to look at the rankings. We'll continue to also look at the issues around the judicial system and probably a way out to ensure that the system is free from all encumbrances, because that is the only way we can get justice in the country. Well, you are still watching Politics HQ. We quickly go on a very short break. When we return, we'll continue with the conversation. Just stay with us. You're watching Politics HQ on New Central Television, and tonight we have been looking at the Nigerian judiciary and, of course, how it can be free from all forms of influence, most especially on the part of the executives, the political class, so to speak, and how justice can be effected in all corners and in all situations and cases. And earlier on, I talked about the fact that Nigeria's judiciary scored about 0.48%, looking at a global ranking, putting Nigeria at 77 globally, according to the 2024 World Human Rights and Rule of Law Index compiled by the World Justice Project. And this actually talks about the position that Nigeria's judicial system is, and the challenges that it has been faced with so far, and what needs to be done to correct those anomalies. We've had situations where a miscarriage of justice has pervaded the system, how Nigerians do not feel comfortable or cannot trust the verdicts or the sentences of court cases, so to speak, and the fact that there have been questions around even if the judicial system is actually the common or the last resort for the common man. So these are part of the issues that we have been trying to bring to the fore on the show tonight, to see maybe there's a way whereby Nigeria's judicial system can be independent and we can have justice being served on all sides. And of course, we've had situations whereby there have been talks around why will the government be in charge of upward remuneration review for judges, and why they would have to give gifts of cars, of houses, and those things are being seen as inducements for these judges, in a way by the probably might be a skewed judgment being handed down during the court of cases at the court of law. So these are part of the issues whereby we continue to chronicle, and we've also seen situations whereby the political class have been accused of, in a way, trying to stifle justice, and even we've even heard cases whereby lawyers, so to speak, have tried as much as possible to delay justice being handed down. And these are part of the challenges that we are trying to underscore on the show tonight, and bring a thorough and factual perspective to see how we can ensure that independence of the judicial system in the country can be finally gotten. There have been issues around upholding human rights, maintaining the rule of law, evaluating different factors as regards government constraints, corruption levels, civil justice effectiveness, and so many things that have actually bedeviled Nigeria's justice system. And now we have been talking to Afam Osigwe, SAN, President, Nigerian Bar Association, and he will be bringing so much light to the issues affecting Nigeria's judiciary. Thank you so much again for staying with us. I want to believe that the audio quality is quite good and we can have a robust conversation at this time. I'd like you to just confirm, sir, by responding. Okay, so earlier on, you said that you do not agree with that particular ranking that actually pegged Nigeria 77 globally in terms of how it has played out or affected justice in the country. But then we've seen so many cases around how a lot of people feel that justice has been skewed, and the fact that based on technical grounds, the true nature of justice have not been handed down in several situations. So I'd like to point it or to bring it to you why you will say that you do not agree with that rankings when a lot of people do not really trust Nigeria's judicial system.
So if the issue is about judicial independence and Nigeria scoring less than 1%, that is what I do not agree with. I will be one of those that will agree that the perception of the justice system in Nigeria is not as high as it should be. It's at a low point at the moment. If you're saying that some of our courts rely on technical justice, I'll very much agree with you. If you're one of those who will say that some trials in our courts are delayed, and that people's confidence in the courts is low, like I said earlier, I will agree with you. But if we say that judicial independence is basically non-existent in Nigeria, I will not be able to agree with you. But I will agree with you that judicial independence is not as good as it should be. And I try to differentiate between the independence of the judiciary at the federal level and at the state level. And I pointed out that the problem lies more at the state level than at the federal level. What is that judicial independence? Are there questions with it, whether we look at it holistically or we're bifurcating between the federal judiciary and state legislature? Oh, yes, there is a problem. The ranking is abysmally low, and I don't think that despite the challenges we have, it should be as low as the ranking suggests. It's not as bad as it suggests, but there's need for our courts and our judicial officers to act in a manner that improves their perception by the people, that reduces over-reliance on technicality, that ensures that there is substantial justice done in cases before tried by our courts,
that people will go away believing that our courts do more justice than render judgments. There's a whole lot of work to be done about the perception
And
of
now,
judiciary.
now you said something about. Sorry to butt in. You actually said something
The issue
about
of corruption by either lawyers or judicial officers should be seen to be tackled seriously, and those who are found to be involved in it should be shown the way out, and lawyers who are involved in it should be disciplined.
You said that the challenge. You said that the challenges are more pronounced at the state level.
Some of the problems faced
Afam,
is by judges or judicial officers who give judgments that neither accord with reason or common sense or law. Yes, please.
Yes, you actually said that the challenges or the issues are more pronounced at the state level more than the federal level, meaning that we should focus more at the subnationals. What do you mean by that?
Judicial independence. When you talk about judicial independence, in answering your first question, I made a point that many governors make it look as if when the judiciary is funded, they are doing the judiciary a favor. They see the courts as belonging to them, and whatever they give to the court, whatever the state does for the court, is something that they are doing out of their own benevolence, out of their own magnanimity. So they boast about buying cars for their judges, building houses for their judges, funding the courts, as if these are not constitutional requirements, as if these are not entitlements of the court, as if the courts must go cap in hand to the governor before they get them. And that is why the judgments of the court that go to show that the judiciary should be independent and should be able to pretend its own judgment, have financial autonomy, present their budget before the legislature, should be respected. That the judiciary, that the funding should be, that the judiciary should not be tied to the apron string of the judiciary. These are issues we must tackle. But if you're talking about administration of justice, it's an entirely different thing. Some of the judgments emanating from our court, which may have given negative perception that some of our courts do not do justice, have nothing to do with judicial independence, but may be a function of either corruption, poor knowledge of the law, or just incompetence on the part of judicial officers, or some reason making it difficult for the courts to be consistent in their judgment, thereby leading to uncertainty in the law.
But then how can the judicial system attain financial autonomy when the appointment of justices or the judges, so to speak, are done by the governors at the subnational levels and by the presidents at the national level?
So the way a person is appointed does not suggest that because a governor appoints you, a president appoints you, you should not have financial independence. The Constitution has granted them financial autonomy. How you are appointed, how you become a judicial officer should have nothing to do with your ability to control funds or money meant for that arm of government. The judiciary, remind you, is an arm of government, it's an organ of government. So how they get there should be carefully separated from the fact that they are guaranteed financial autonomy. And this financial autonomy is coextensive with the independence of the judiciary. Because when they have to beg for money to be made released to them, there can be some arm twisting, because a court can also be starved of funds as a way of taking away from their independence to bring them to their knees.
That's quite interesting, saying that there's possibility for the judicial system to be starved of funds. So in situations like that, that probably might seem as though they might be cajoled to sway judgments or sentences in the favor of government, so to speak, in such scenarios. Is there a legal process that they can take to address such situation?
So it becomes a political question. It could be a matter for bringing impeachment proceedings against a governor, but then unfortunately, our various houses of assembly lack the political will to take actions in such situations, and so you may rely on either the matter being litigated, and oftentimes the judiciary is also not willing to go to court. It may depend on lawyers or members of the public to litigate it, or to advocate or draw public attention to it as a way of persuading the governors to do the right thing and not try to sit on funds meant for the judiciary, so that the judiciary can independently do what they have to do without being afraid that if judgments not favorable to the government are given, then releases meant for the judiciary will not be given to them.
It's quite interesting if we're seeing a lack of political will on the part of the governors, so to speak, or the political leaders to do the right thing, and of course a lack of sheer will on the part of harbingers of justice to also uphold their own part of the law and refuse not to be cajoled by the whims of the political class on them, then we have a problem. But then there's something that you also mentioned about the giving of cars.
We shall have a problem.
Of course. The issue around gifting of cars, houses, remuneration, review for the judicial arm of government. Now, that seems to be also raising a question. In what you've said, it seems as though it is not a bad thing. But then when we see those things happen, how can the judicial class, so to speak, or the judiciary system, or place within that particular system, stand their ground to do what is needful, despite the fact that these things are given to them? Because it seems as though it is to encourage them not to be biased in their judgments, but then the opposite is what we see.
Let me say this. If my earlier statement is being misconceived by you, I say there's nothing wrong with it. In any situation where a governor gathers judges or brings a chief judge or any person whatsoever to display to the public that he's giving them cars as if he's doing them a favor, as if he's being very magnanimous and generous in giving them cars, it is condemnable. That is building courtrooms or quarters for them. It is unconstitutional, it's demeaning, and it takes away from the independence of the judiciary. If the judiciary needs cars, if the judiciary needs houses for the judicial officers, if they need courtrooms, if they need anything, it should be put in the budget of the judiciary, and the judiciary should be able to manage the budget meant for them and acquire those things. No member of the executive should do that for them. Because nobody does that for the legislature.
But then why can't the judiciary? Why can't the judiciary
should be subjected to such humiliation?
Why can't the judiciary also reject? If they feel that those kind of benevolent acts have ulterior motives behind them, why can't they say they don't want it?
I am not talking, let us leave out the ulterior motive. The fact of it, whether there is an ulterior motive or not, is condemnable. I don't want to start inquiring into the state of mind of the governor. It belittles the judiciary and should not, in any circumstance, be tolerated.
Okay, well, fine.
If the judiciary needs anything, it should be put in the budget of the judiciary. The judiciary should be allowed to handle it. No member of the executive should do that for the judiciary.
Okay. Well, some people actually argue that even the resources allocated to the judicial system is not enough. So for them to probably bend a bit to accept these things, we cannot excuse it from them. But then we are going to come to that. No, we are going to.
No. Please. We cannot make it look as if you're giving a gift to the judiciary. Until we get away from that mindset, we'll never be able to address this issue.
Well, we are going to come
because
back.
The executive cannot go to the legislature to receive gift. The executive cannot continue to pretend to be a big brother to the judiciary to determine what they get. It should go to them as of right if it is a budgeted item. It is not for the governor to share them and bring cameramen. It's humiliating. It takes away from the individual. Let us call a spade and situate this conversation.
All right, we'll continue with the conversation anyway. You're watching Politics HQ. We go on a very short break. When we're back, we will continue to talk about this. We are talking about Nigeria's judicial system and what can be done to give it some sort of freedom when it comes to the administration of justice in Nigeria. We have been talking to Alpha Mosigwe and President Nigerian Bar Association. And of course, in your response, of course, everybody understands that it's condemnable to have some sort of ways by which the political class tries to encumber the judicial judgments, so to speak, or the ideologies of the judges when it comes to cases brought before them. But then we'll still go back to the issue around funding of the judicial system. It's being talked about that Nigeria's judiciary is underfunded, and that seems to be a lot of challenge when it comes to independence or being independent when it comes to the administration of justice. I'd like you to speak to that in terms of resources allocated to them and how that can be improved.
Okay, so in many states, the governors refuse to allocate adequate resources to the judiciary because according to them, the judiciary does not generate revenue. They feel that the judiciary should, for them to get more funding, they should generate revenue. But the act of judging or adjudication of dispute It's a much needed social service that should not be operated profitably. It should not be operated with a profit-making mindset. So the judiciary in many states is underfunded. And if not for the fact that at the moment, salaries and allowances meant for judicial officers, either at the federal courts or the state high court, state courts, come from the NJC, many states will be owed, many state judicial officers will be owed their salaries. Indeed, until the recent alteration of the constitution, which enhanced the salary of judicial officers and also took away the responsibility for payment of their pensions from the state and gave it to NJC, many retired judicial officers were being owed their pensions and other entitlements. So the governors in some cases also may deliberately be starving them on the funds so that the chief judges or judicial officers would have to beg them to fund them or to perform some much needed or release money for some much needed thing in the infrastructural development and the judiciary, believing that the principle that he who pays the piper will dictate the tune will apply, so that in so doing they can make some requests that may not ordinarily be right to make. And you can't rule out the fact that such things may work on the mind of the judges or judicial officers. So I reiterate that the judiciary should be well funded, and the governor should not take away some items that is better handed over to the judiciary to manage and be doing them and be presenting the judicial officers or judges, chief judges like school children before the whole world to tell them how well I treat them, see how good I've been to them, see the beautiful cars I bought to them. My predecessor did not do. Look at the courtroom I built for them. They should be allowed to do these things for themselves as a way of ascertaining their independence and minimize their contact in that regard with the executive, so that they will be able to determine for their cause what they need and administer them in a manner that will shield them from political interference or pollution.
So permit me to ask, have there been any sort of rapport, maybe some sort of engagement with the governors on matters like this? Have these things or these concerns been tabled to them to let them understand the standpoint of the Nigerian judicial system, the members, so to speak, and let them also understand their role, so that by the time we have an understanding of this cross-pollination of ideas and ideologies, then both arms can know what they need to do and begin to do what is right for the growth of Nigeria's judicial system and, of course, the administration of justice in the country. Have there been some sort of, talks around this?
Of course. Many fora, either at the level of the Bar Association, either in a different fora, engagement between the judiciary and the executive. This point is made in many non-related public discourse by civil society organizations, by court users and every person. And even some have been litigated. One of them was by Judicial Staff Union of Nigeria, and then by Olisagbakoba. People have gone to court. There are judicial pronouncements on this. It's not an issue of lack of knowledge. It's not an issue of absence of provision by the law, but deliberate refusal by political office holders to do the right thing. Willfully manipulating the finances of the judiciary as a way of exerting control. It is such a show of power. Starve the judiciary of funds, make them beg for funds, tighten the screw, starve them of financial aid, so that they will not be too active or they do not be act in such a way that if the executive cannot make demands on them. It's not for want of knowledge. It's a political show of power, if I could use that expression.
Okay, so there's no way we can conclude on this conversation without not bringing to the table the issue around Dele Farotimi, who is also, interestingly, a legal luminary in Nigeria. And a lot of Nigerians feel that the allegations leveled against him are defamation of character, so to speak, the handling of the matter, and how the issue around the former Kogi State Governor Yahaya Bello, how his own case was handled, seems or smacks of some sort of favoritism, so to speak. Now, let's look at what has been leveled against him in terms of defamation of character. What is your own take on that? And how do we balance between handling cases that involve state actors and ordinary Nigerians in the country?
Well, I'm sure you would not want me to comment on the matter that is pending before the court. As you say, the matter is sub judice, and so I will not be able to comment on it. But I must say that sometimes different individuals, depending on their status in society, sometimes the way the court treats them, the kind of bail condition they are granted, sometimes give the impression that the Orwellian state of nature, where all animals are equal and some are more equal than others, is operational in our justice system. That we don't have an even-handed system where you can be certain that whether rich or poor, big or small, that individuals will expect the same kind of treatment by a court. But then again, I warn myself that how a court, that what a bail condition a court imposes on a suspect or a defendant, it depends on the discretion of the court and the antecedents of the persons and the nature of the charge. So, while not commenting on any particular case, I will agree with you that sometimes how individuals get treated in criminal cases sometimes give the unfortunate impression that is because all animals are equal and some are not more equal than others, and that shouldn't operate in our criminal justice system. But then it happens, and we hope that we come to a day where, irrespective of who you are, irrespective of where you're coming from, that you'll be able to expect and get even-handed justice from our courts.
So if you say this, a lot of Nigerians or a lot of people might feel that there is more on the part of the judiciary to actually guard their acts in terms of probably in the course of administering justice, do what is fair and balanced. That is what, the impression that some Nigerians are actually having. Because it seems as though if we begin to see technicalities and these kind of judgments and these bail conditions that seem not to be consistent in the eyes of those that might not really understand what the full extent and the interpretation of the law is, may seem as though it is stifling freedom of expression or justice not being given as at when due to who is deserving of it based on the facts presented before the judge.
I have made a point to you that I agree that sometimes the perception is that the rich get away more lightly than the poor. I've also agreed with you that sometimes the impression is that there's no even-handed treatment of persons. And I also agree that sometimes it would appear that the judicial process would appear to work harder on persons and in some cases work to suppress the right to freedom of expression. But then this does not tell the full story. And every case must be taken on this individual merit because there is also no one size that fits all. Individual judge in granting bail or in treating a defendant or an accused person in a case must look at the nature of the charge, the character of the person, his antecedents, and a whole number of factors in determining what condition to. What is important is that the judge acts judicially and judiciously, and so we only treat individual cases on their own merit. I cannot sit here and then pretend to have a holistic position that will address all cases. But then our courts should act with some degree of certainty and predictability, and which in some cases we don't get that, and that is why, to that extent, I will agree with you.
Well, we're still going to probably dwell on that a little bit more, even as much as you're trying to, of course, let us understand your position. At least maybe some position that you can take is if there's a need for a total overhaul of the system or maybe some reforms that can come into play. But I'm going to take your reaction after this short timeout. So we'll go on a very short break. We'll be back, and when we do, we'll be concluding on this. And of course, on Politics HQ, we're looking at Nigeria's judicial system and how we can improve the system to ensure that justice is served. I've been talking to Afam Osigwe, SAN, who is the president of the Nigerian Bar Association. Of course, I must say that it's been profound in terms of your contributions on the show this evening. Thank you so much. But before I let you go, I need to take your position on. Of course, let's look at what is the position of the NBA in terms of the cases of police brutality that we've seen, the arrest of lawyers, the somewhat manhandling of whistleblowers, and those who have spoken against government, so to speak. What is the position of the NBA on this?
Well, the position of the NBA is that law enforcement agencies, and indeed every member of the position of the society, should that all these classes should respect the right to freedom of expression, and that where a person is seen to have violated it, that whoever feels aggrieved by the same should use the civil law of tort and sue for damages. But we have an increasing situation where the Cybercrime Act is being used to stifle voices of dissent and opposition. And I think we should look at it from a constitutional prism and ask ourselves whether these do not violate the right to freedom of expression. And also about police brutality, I think that there should be more oversight of the functions of the law enforcement agencies. There's a lot of extortion and brutality going on. There's a lack of accountability about persons who are put in detention, how long they are detained, and a lot of extortion of money from these persons. And sometimes also the lack of communication concerning their whereabouts. The members of their family do not know. And sometimes people are taking over long distances and clamped into detention without their whereabouts being known. There's a lot to be done about this. We must overhaul our criminal justice system such that no law enforcement agent should be able to do that to any individual without being held accountable. People are being held for long periods of time in detention facilities without being charged to court, without being released on bail, and without anything being done about it. And that's why the NBA has been calling on chief judges to direct magistrates and judges in their courts and under their control to carry out the statutory duties imposed on them by the Police Act and the Additional Criminal Justice Act, to visit detention facilities, to inquire into the number of persons being detained there, to order that some of them, those of them that deserve to be released, and that those who should be charged to court be charged to court. And also to review, to direct that no magistrate should order the remand of a person without having a return date. You can't order the indefinite detention of a person and no charges filed against such a person. And indeed that we should apply, I think, section 31 or 32 of the Police Act, which requires that before police can charge any, after police has concluded the investigation, before it can charge to court, it shall mandatorily obtain the advice of the Attorney General. That provision was put in the law for a reason, to avoid the abuse of prosecutorial power by the police. And we must do a lot, because the suggestion that over 70% of our prison inmates is made up of persons who are awaiting trial is not only worrisome but frightening. It should not happen in any society. And we must do everything to ensure that the remand process is not used to unduly victimize persons, is not used to take people out of circulation or force them into paying a bribe or force them into being silenced. We must ensure that our justice system is such that engenders confidence in the mind of the people and is not abused by any person, whether low or high in the society.
I think that's a fantastic way to actually land. Just to wrap this up, Osigwe, and what is your mean, or probably should I say your projection for Nigeria's judiciary, probably in the next couple of years, as regards these things you've mentioned? Can Nigerians trust that probably in the next few months thereabout, things will change and they will begin to trust the judiciary once again?
When I say this to you, building an institution is not easy. Rome, they say, was not built in a day. We have a new chief justice of Nigeria who, in her first public outing at the legal year of the Supreme Court, made a number of policy pronouncements in her address. And some of these will take a lot of stakeholder engagement and will probably take years. What is important is that we are identifying problems and challenges we need to tackle. And we tackle them. I mean, it's not like cooking indomie. It's going to take quite some time. And so we're going to build institutions. We're going to change mindset. We're going to put the right persons in the right positions. We're going to do a lot of work. We're going to do a lot of changes, and this will probably take time. So I'm afraid I will not be able to satisfy you by making a projection. But I can only say that it's going to take time. It will require a lot of patience. It will require a lot of determination and focus. But with determination, with the right persons in the right position, we'll get there. It will take time, but taking out a rot from a system, a systemic rot in a system, both within the law enforcement agencies, prosecutors, lawyers, judges, is going to take time. So I'm afraid I will not be able to project. The important thing is that let us be headed in the right direction, and someday, sometime we'll get there.
Hopefully we'll get there. Thank you so much, Afam Osigwe, President Nigerian Bar Association, for your time on the show.
Amen.
And that's how we bring to a close to this edition of Politics HQ. And we hope that the right things will be done for the growth of Nigeria, so that Nigerians can also have that bit of confidence in its judicial system. I am Lekon Obanjo. Enjoy the rest of your day.